If I were to ask you for a list of what you thought were the most frequently cited Supreme Court cases, you'd probably get a few. You might guess the most referenced Supreme Court case of all time, Brown v. Board of Education, which desegregated public schools and kicked off a generation of civil rights cases. You might have guessed number 2 on the list, Roe v. Wade, the landmark abortion rights case. But you might not have guessed the next in line, Estelle Griswold versus the state of Connecticut. It's the case that identified the constitutional right to privacy. That right to privacy prevents state governments from deciding whether a couple is allowed to use birth control, or which people it would be illegal for you to have an intimate relationship with. The idea of the right to privacy is a bit controversial because the word privacy doesn't actually show up in the Constitution. To understand this court case, we're going to have to go back to Connecticut in the 1960s.
We're about to take a brief tour of Connecticut. In this astronaut's eye view from outer space, it appears small geographically, but it looms increasingly large the closer one approaches.
At the time, Connecticut law made many forms of birth control illegal. Condoms, diaphragms, IUDs, and the pill. This was a morality law. The political majority in Connecticut believed that sex for any purpose other than procreation was immoral.
During the fall, a drive amidst the breathtaking foliage in these hills is a must.
Needless to say, a lot of people weren't happy about the law. Enter Estelle Griswold. Estelle was the executive director of Planned Parenthood of Connecticut, and although a later Planned Parenthood Supreme Court case would deal with abortion, this had nothing to do with that. Because of the ban, Planned Parenthood of Connecticut would drive their patients to New York to be able to get the pill and other banned forms of birth control. Estelle decided that instead of driving her patients across state lines, she was going to start providing birth control in her New Haven, Connecticut clinic, suffer the consequences, and challenge those consequences in court, which is exactly what she did. In 1961, she and a physician at her clinic were arrested, tried, and fined for their part in providing birth control. Griswold challenged the ban all the way up to the Supreme Court and argued that Connecticut's birth control ban was unconstitutional. The question that came before the Supreme Court was whether they agreed with Estelle Griswold that the ban was unconstitutional, and more importantly, if they did, under what part of the Constitution. At the time, there were several arguments you could make. The 14th Amendment had been used to protect personal liberties before. The Equal Protection Clause could have been used because this gender-neutral law was only being enforced against women. And when the Supreme Court released its ruling on this case, by a 7-2 margin, they said that they agreed with Estelle Griswold and that the law was unconstitutional and struck it down. But I need to explain something about how the Supreme Court works before I go any further. Each Supreme Court decision is actually a collection of several individually written opinions. In Griswold v. Connecticut, 6 of the 9 justices wrote their own opinions. Now, the tricky part is to get at least 4 other justices to sign onto your opinion. When that happens, your opinion becomes the majority opinion and then becomes the official Supreme Court interpretation and is enforceable across the country. The justice who got 4 of his colleagues to sign on to his opinion was William O. Douglas, and when we asked him which part of the Constitution had been violated by Connecticut's birth control ban, he said, all of them, just the whole Constitution. Justice Douglas was an avid outdoorsman, and to him the Constitution was like a mountain range, which couldn't exist without a glow of light from a setting sun and the shadows cast by their peaks. And like a mountain range, the Constitution had this glow and shadow, or as he would call them, emanations and penumbras. And in the Constitution's emanations and penumbras, you could see a right to privacy that was violated by a birth control ban. He saw the right to privacy in the emanations of the First Amendment's implied right of association, the penumbras of the Fourth Amendment's prohibition of unreasonable searches and seizures, the Fifth Amendment's right against self-incrimination. He saw privacy in the emanations and penumbras of the Third and 14th Amendments. To Douglas, the right to privacy wasn't in one part of the Constitution, it was in a lot of them. And if that logic doesn't sound quite right to you, you wouldn't be alone. The right to privacy here is what is known as a penumbral right. It's a right that's not explicitly mentioned, rather it lives in the shadows of another right. Both sides of the political aisle like penumbral rights for different reasons. The Fifth Amendment gives you your Miranda rights for if you're arrested, and the Second Amendment gives you your right to self-defense. You definitely have both of those rights, but neither of those are specifically written into the Constitution. Now, in this case, that logic was stretched a bit. The author of the opinion, William Douglas, had a reputation for writing sloppy and hastily written opinions. It's been ridiculed by conservative and liberal judges and scholars. Conservative Supreme Court Justice Clarence Thomas would hang a sign in his office that said, "Please don't emanate in the penumbras." The two justices who disagreed with Estelle Griswold and thought the birth control ban was perfectly constitutional argued that if the Supreme Court started looking into every state law that offended some American ideal, then they'd be giving themselves an overly broad veto. Could the Supreme Court now start striking down laws that they thought violated a constitutional right to prosperity? Three other justices would argue against that point and say that it's the Ninth Amendment and its reference to rights that don't actually show up in the Constitution that protect American rights, whether they're written down or not. They'd argue that there wouldn't be any constitutional right to party anytime soon because it's not rooted in American tradition and history, which you'll have to forgive them, this was 20 years before the Beastie Boys.
You gotta fight for your right to party.
In his opinion, Douglas wrote, "Would we allow the police to search the sacred precincts of marital bedrooms for telltale signs of the use of contraceptives? The very idea is repulsive to the notions of privacy surrounding the marriage relationship." And an overwhelming majority would argue that that idea and his result were the right ones, but that his reasoning for getting to that result wasn't. Douglas's Emanations and Penumbra's logic, as poetic as it was quickly and easily forgotten. This case still comes up in Supreme Court nomination hearings. Back in the 80s, now President Joe Biden got in an argument with a judicial nominee who disagreed with the case.
The fact that it wasn't prosecuted did not mean that it wasn't a crime, does it?
I have more to say about that.
Through this day, senators will ask judicial nominees about their thoughts on Griswold, and they have to awkwardly agree with the result while dancing around a full endorsement of its logic.
I agree that Griswold is now, I think, understood by the Supreme Court as based on the Liberty Clause.
The Supreme Court doesn't usually talk about an official right to privacy anymore, but the idea of privacy in our Constitution lives on. It was a central theme in a 2003 Supreme Court case that overturned state laws that dictated which sex positions were illegal. Those laws targeted gay men and were overturned because they criminalized consensual adult sexual relationships in the privacy of a bedroom. When the state of North Carolina passed a law that would have forced transgender persons to use bathrooms that aligned with the sex on their birth certificate, the plaintiffs would argue that that law, among other issues, was a violation of their right to privacy. Three judges in this case wrote opinions arguing that there was a less poetic but much more simple and much more coherent argument to strike down the Connecticut birth control ban and protect privacy in America. For them, the case came down to one word in the 14th Amendment: liberty. The Supreme Court would get an opportunity to define just what liberty meant when Norma McCorvey sued Henry Wade, the state attorney in Dallas, Texas. Because she was suing for her right to have an abortion, she would use a pseudonym, Jane Roe, and the definition of liberty that came from that case would come to define Supreme Court ideological splits to this very day.